This is part 5 of Federalist 81. We'll start with paragraph 18. Let us resume the train of our observations. We have seen that the original jurisdiction of the Supreme Court would be confined to 2 classes of causes, and those of a nature rarely to occur. In all other cases of federal cognizance, the original jurisdiction would appertain to the inferior tribunals, and the Supreme Court would have nothing more than an appellate jurisdiction, with such exceptions and under such regulations as the Congress shall make. So we've finished. We read the last paragraph and I kind of ran out of time, but one of the things that I just want to say is that one of the first big cases that went to the Supreme Court of the United States, it was a case called Chisholm versus Georgia. It was a citizen of state of South Carolina had sued the state of Georgia, and the court ruled on his behalf and said, yes, you could sue a state. And anti-federalists who were really concerned about states losing their power and sovereignty, they really raised hell about it, and that led to the passing of 11th Amendment. That was the first amendment after the Bill of Rights that was added to the Constitution in 1798, because they wanted to keep state authority in place. They didn't want to give too much power to the central government and the courts. So keep that in mind. This is in the background. These people, anti-federalists, are really, really concerned that if this federal judiciary becomes powerful, gradually it will start interpreting the spirit of the law rather than the letter of the law. And then that can mold the law any way it wants to, can take power away from states gradually and make state sovereignty non-existent at that time. And this was a big deal to them. The next paragraph, the propriety of this appellate jurisdiction has been scarcely called in question in regard to matters of law, but the clamors have been loud against it as applied to matters of fact. Some well-intentioned men in this state, deriving their notions from the language and forms which obtain in our courts, have been induced to consider it as an implied supersedure of the trial by jury in favor of the civil law mode of trial, which prevail in our courts of admiralty, probate, and chancery. Another thing that you might want to keep in mind is that it was really, really important for Americans back then to have jury trials. And it was an issue in this Constitution that had come out of Philadelphia Convention before the Bill of Rights was added. They were saying that you're gradually going to take juries out of this judicial system. And that is an attack on our liberties. So when you hear, when he says matters of fact or matters of law, juries were there to find the facts out, right? To find out the facts. So they're saying that's why jury is important. And they were really, really worried about it. That's why they forced the first Congress. They said, we'll ratify this Constitution only if you promise that there will be a Bill of Rights. And that, as I've mentioned before, 5 of the first 10 amendments have to do with the judiciary, because they wanted to make sure that jury trials and a few other things are not violated. So let me continue reading this. A technical sense has been affixed to the term appellate, which in our law parlance is commonly used in reference to appeals in the course of the civil law. But if I'm not misinformed, the same meaning would not be given to it in any part of New England. There, an appeal from one jury to another is familiar both in language and practice, and is even a matter of course until there have been two verdicts on one side. The word appellate, therefore, will not be understood in the same sense in New England as in New York, which shows the impropriety of a technical interpretation derived from the jurisprudence of any particular state. The expression taken in the abstract denotes nothing more than the power of one tribunal to review the proceedings of another, either as to the law or fact or both. The mode of doing it may depend on ancient custom and legislative provision. In a new government, it must depend on the latter, and may be with or without the aid of jury, as may be judged advisable. If, therefore, the re-examination of a fact, once determined by a jury, should in any case be admitted under the proposed Constitution, it may be so regulated as to be done by a second jury, either by remanding the cause to the court below for a second trial of the fact, or by directing an issue immediately out of the Supreme Court. The next paragraph, let me check something out real quick. Okay. Just keep in mind that for the first time reader, or even for the second time reader of the Federalist Papers, these subject matters will be a little condensed and complicated. That's why I have all these websites that I've suggested to you to go and watch some videos and try to learn a little bit more the history of the era, and also how the British system had influenced the U.S. system, and gradually reflect on these Federalist Papers. They will make more sense, especially when he talks about law and stuff like that. You have to become kind of familiar with what they meant by common law. The common law of England was a body of procedures and laws that for over the centuries had been in place in England. And judges would look at the previous cases and look at precedent, what they call, and try to judge on every case, remembering what past judges had said. So this gradually accumulated the procedures and also the laws into what became the common law. And actually these common laws were in effect in the colonies in the United States before, of course, United States became United States. So they were in fact in place even after the Revolution, unless a law was replaced by a statute, a law written by the state legislature or by the Congress of the United States. Those common law things were still acceptable and in practice. So, like I said, when you watch lectures that are presented here or in National Constitution Center or on C-SPAN, this will gradually help you build the foundations you need to learn these Federalist Papers even more in depth. I accept that for me to do this on these short videos, there will be some limitations. I have to accept that myself, and I have to share that with you. So we'll come back, and in part 6, I'll finish the rest of this Federalist paper. Okay, see you then.